Good afternoon, everyone. First, let me join the thanks for the organizers of this conference, especially Owen and all the other organizers. And special thanks for combining together the last two sessions, this and the previous one, which I think gives a very interesting, comprehensive picture on law, religion, and bioethics, which is it's very important, and the fact that you managed to gather so many people, rabbis and scholars and doctors. So it's very, very unique and very, very, I think, has an important contribution to the area. My objective in this lecture is to point on a meta-legal interaction between Jewish law and the legal and bioethical discussion of posthumous fertilization, in particular as regards to sperm retrieval of fallen soldiers. In this respect, I would like to analyze two rationales, individualistic and familial, behind the specific modern debate over postmortem sperm retrieval and their equivalent in the halachic discussion of its old predecessor, the law of levirate marriage. So this will be my topic in general. We would start from levirate marriage. Israel, one word about assisted reproduction in general, as you have heard, is quite open to assisted reproductive technologies, and posthumous fertilization is no exception. But the desire for continuity, which stands at the basis of posthumous procreation, posthumous fertilization, is not a modern phenomenon. Rather, it is well rooted in the history of human beings since the old biblical commandment to be fruitful and multiply. Obviously, this desire could not be satisfied using posthumous fertilization until recent decades, but similar objectives could be achieved, at least partially, through classic family relations. In the Jewish tradition, the laws of levirate marriage are the legal structure whereby the desire for continuity and a few other objectives, like providing the widow with some financial sources and financial protection, could be satisfied. In this respect, levirate marriage can be regarded as the ancient biblical predecessor of the modern posthumous fertilization practice. But what exactly is the relationship between the two? Before discussing this question, it is necessary to provide some basic backgrounds as regards levirate marriage. According to Jewish law, if a married man dies childless, his wife should marry his brother in what is defined as a levirate marriage. In fact, most communities do not practice it today, but the general idea still exists. The purpose of levirate marriage is to ensure continuation for the deceased, as it is stated, and the first son whom she bears shall succeed to the name of his brother who is dead, that his name may not be blotted out of Israel. Now, you have in front of you the old chapter, the old paragraph, which I would not read. Just pay attention to the bolded section. Shall carry out the name of the dead brother. And I picked up two translations, two modern translations, just to show the dilemma in the word, especially in the word name. What does it mean, carry out the name? We can see on the one hand, name can be understood literally as just naming the child, the firstborn, the child who will be born from the new relationships after the name of the deceased. This is one interpretation. Second interpretation, it's an interpretation that is based on more contextual meaning of the word name in the Bible. And here name can be understood also as kind of inheritance, and especially inheriting the land of the deceased. In the story of the daughters of Tzlofchad, the daughters tell Moshe, why should the name of our father be taken away from his family because he had no son? Give us a possession among our father brethren. So name means possession. The Talmud, now I said about those two translations, I think that it was two modern translations. You can see this basic dilemma between the meaning of the name, whether it is kind of inheritance or kind of renaming of the child after the disease. A related dilemma is the word brother. What does it mean, brother? And here, if we take the literal meaning, brother will be the deceased that the child that will be born will be named after him. But there is a very interesting Talmudic interpretation that follows the idea of inheritance, that interprets name as inheritance, and interprets the one who provides with the right to inherit to the brother, to the Levi, to the one who marries the widow. So brother will be the real brother, the brother of the one who marries the widow. The Talmud itself has some doubts, or consider those two options. You can see the basic Talmudic source. I would not read it. Those of you who can both read and listen, you can do both. If you cannot do both, just listen to me and you should trust me. But the Talmud gives the two options and decides to adopt the contextual meaning of a name, which means that the born child doesn't have any obligation to be literally named after the deceased, but rather the brother, the one who marries the widow, inherits the property of the deceased. Very interesting. This basic dilemma continues also in post-Talmudic commentators, and I'll read one, I think it's interesting interpretation of Marie Cras, who lived in France in the 12th century, and he gives the two options and also testifies about the practice in his place, not exactly in France, but more in the German areas. And he says as follows, and I quote, "The Jews in Mainz and Worms practiced that, God forbid, when such a thing happened in their time, they require fulfillment of the commandment by the actual giving of the deceased's name to the born child." This is the first interpretation. "And then also by inheritance of the deceased by his brother to fulfill the Sopheric interpretation." So Rabbi Yosef Kra gives the two options and testifies that both were practiced in his time. Let us leave for a few moments the discussion of levirate marriage and turn to postmortem sperm retrieval. In several cases in recent years, family courts approved postmortem sperm retrieval when there was no explicit will of the deceased or his or her spouse, following the Attorney General guidelines of 2003. In two cases, however, a conflict arose, and the involvement of soldiers in those cases, both young soldiers who died in tragic circumstances, made the issue much more complex. The first case was the case of Shaked Meiri. Shaked Meiri died on 2004, and his parents requested to use his sperm to impregnate a woman against his widow's will. At the beginning she agreed, but then she changed her mind. She had new relationship and children from those new relationships. The request was approved by family court, and the widow's appeal to the district court was rejected, but then it was changed. In a lengthy and reasoned verdict, the Supreme Court denied the right of the parents to decide regarding the use of their dead child's sperm and gave his widow the exclusive right to make such a decision. The court reasoned that parents should not be involved in their child's decision to procreate, and that this is a private decision of the couple. Now the picture here, it's a terrible picture. You can see the mother of Shaked Meiri, and she takes out the name of the widow from his grave because of her objection to the process. In the second case, the case of Shaked Meiri, who died at 2012, following the Supreme Court's decision, the second case of Omri Shachar, who died at 2012, following the Supreme Court's decision in the Meiri case, the district court disallowed the use of his sperm by his parents. Omri's spouse supported the process. Here they were not married. She was his girlfriend, and she supported it, but she didn't want to be active in this process. And then the district court consequently reasoned that despite her support, the process could not be performed by the parents. We need the actual performance of the process by the spouse. The decision was approved by the Supreme Court. These cases were frequently mentioned and debated in the public sphere. The court decisions, however, were not the final word on this issue. proposed legislation was submitted to the Knesset, the Israeli parliament, in June 2017, about a year ago, regarding the right to postmortem sperm retrieval of fallen soldiers. Knesset members from across the political spectrum supported entitling the parents of deceased soldiers to use their son's sperm. And the fact, it was a private proposal, but the fact that it is supported by parties from the left and the right, I think it gives it much more power, and at least it testifies about the acceptance of the idea by wide spectrum of the society in Israel. The explanation appended to the proposed legislation provides the rationale behind the proposal, which is different than that of the Supreme Court, as we will now discuss. The Supreme Court decision in Shaked Meiri's case focuses on will, that of the deceased person. Providing his widow with the right to decide was described as a means for revealing the presumed will of the deceased. His parents' request, on the other hand, focused on different kind of arguments, but the court was not convinced. Continuity, parents' feelings, society's collective responsibility to the soldiers and his family. This is emphasized in the explanation of the proposed legislation, which goes in this direction. You can see it in front of you. And here I'll read a very short sentence. The state of Israel owes a moral obligation to the bereaved families who have lost what is more precious to them. The responsibility of the state that sends its sons to defend its security must be expressed also in affording the possibility of making use of advanced technologies that will enable the bereaved families to have offspring from the deceased and to maintain the dead soldiers' continuity. These two sources, the court and the proposal, reflect different kinds of argumentations or different conceptualization of the right to posthumous fertilization. The first focuses on will of the deceased. This conceptualization may be defined as an individualistic right to reproduce posthumously. Now, it's a great issue whether dead persons have rights, or maybe the living persons are the agents of the dead persons, and unfortunately, I will not be able to discuss it here. The second focuses on family continuity, feeling of responsibility, and the need to compensate the families. It may be defined as a familial right to reproduce posthumously. The proposal thus builds a different justification of postmortem fertilization, one that is based on shared communal values rather than individualistic ones. The result is a dramatic conceptual change from an individual right to reproduce, to a familial right to reproduce, which makes it possible to provide family members, in addition to the spouse, with the right to initiate posthumous fertilization. An interesting point in this respect is that the proposed legislation doesn't intend to adopt this argumentation for all cases of posthumous fertilization, but rather to limit it to fallen soldiers. Time, however, will tell us if the proposal's conceptualization will be adapted in practice for soldiers. It probably will not happen in this case in Knesset. We will have to wait to the next election, or even whether it will be expanded in the next step to regular cases as well. Meanwhile, the two conceptualizations coexist in the political, public, and intellectual domains. On the basis of the analysis of the previous part of levirate marriage and the discussion on postmortem fertilization, we can now make the next important step, which propose a link between the two. The two different concepts of posthumous sperm retrieval are close to the two objectives of levirate marriage. As discussed earlier, there are two possible interpretations of the verse "shall succeed to the name of his brother who is dead." And these interpretations reflect different objectives of levirate marriage. Let me just go back to a slide which I skipped, and here you can see it in front of you. Okay, thanks. It is close to our first, the understanding of name, as naming the child, is close to our first conceptual definition of postmortem sperm retrieval as an individualistic right. Name as inheritance right, on the other hand, following the second interpretation, is meant to secure the interest of the family in the deceased's property, in particular regarding his land, and especially if he provides those rights to the brother, to the lever. This objective is thus close to the familial or communal conceptualizations of postmortem sperm retrieval. Culture and tradition obviously affect the discussion of assisted reproduction in general. And we heard many times today on the importance of the verse to be fruitful and multiply and so on, but also other historical, cultural factors, like the results of the terrible Holocaust and other kinds of cultural phenomenon. Culture and tradition probably also influence the discussion of postmortem sperm retrieval in particular. It is reasonable to assume that, thus, that the modern debate is implicitly derived from, or at least culturally inspired by, the ancient hermeneutical debate about the objectives of the traditional commandment and practice of levirate marriage. The analysis of the modern debate, as we made here, reveals equivalence to the two rationales of posthumous fertilization, which are found in the old predecessor of the modern technology, levirate marriage. Within the biblical and Talmudic sources, we found representations of, and maybe even kind of competition between the two rationales, the individualistic and the familial. We argue accordingly, and here I'm concluding, we argue accordingly that this old tradition influences the modern discussion of a postmortem sperm retrieval directly or indirectly as a form of inspiration. The two rationales coexist in the Jewish heritage and culture, and both play a role in shaping modern positions as regards posthumous fertilization. Thank you very much.
Thank you very much. Thank you very much for your talk.